Hello! Welcome to the Study With Me series of Law School Buddy. I have prepared audiobook materials following the syllabus of the Philippine bar exams dedicated to our law school students. I hope that this audiobook can help with your study and review. Let's begin. This episode will cover Title VII, Adoption, Article 183. A person of age and in possession of full civil capacity and legal rights may adopt provided he is in a position to support and care for his children, legitimate or illegitimate, in keeping with the means of the family. Only minors may be adopted, except in the cases when the adoption of a person of majority age is allowed in this title. In addition, the adopter must be at least 16 years older than the person to be adopted, unless the adopter is the parent by nature of the adopted, or is the spouse of the legitimate parent of the person to be adopted. Article 184. The following persons may not adopt. 1. The guardian with respect to the ward, prior to the approval of the final accounts rendered upon the termination of their guardianship relation. 2. Any person who has been convicted of a crime involving moral turpitude. 3. An alien, except a former Filipino citizen, who seeks to adopt a relative by consanguinity. B. One who seeks to adopt a legitimate child of his or her Filipino spouse. Or C. One who is married to a Filipino citizen and seeks to adopt jointly with his or her spouse, a relative by consanguinity of the latter. Aliens not included in the foregoing exceptions may adopt Filipino children, in accordance with the rules on inter-country adoptions as may be provided by law. Article 185. Husband and wife must jointly adopt, except in the following cases. 1. When one spouse seeks to adopt his own illegitimate child, or 2. When one spouse seeks to adopt a legitimate child of the other. Article 186. In case husband and wife jointly adopt, or one spouse adopts the legitimate child of the other, joint parental authority shall be exercised by the spouses in accordance with this code. Article 187. The following may not be adopted. 1. A person of legal age, unless he or she is a child by nature of the adopter, or his or her spouse, or, prior to the adoption, said person has been consistently considered and treated by the adopter as his or her own child during minority. 2. An alien with whose government the Republic of the Philippines has no diplomatic relations, and 3. A person who has already been adopted, unless such adoption has been previously revoked or rescinded. Article 188. The written consent of the following to the adoption shall be necessary. 1. The person to be adopted, if 10 years of age or over. 2. The parents by nature of the child, the legal guardian, or the proper government instrumentality. 3. The legitimate and adopted children, 10 years of age or over, of the adopting parent or parents. 4. The illegitimate children, 10 years of age or over, of the adopting parent, if living with said parent and the latter's spouse, if any. And 5. The spouse, if any, of the person adopting or to be adopted. Article 189. Adoption shall have the following effects. 1. For civil purposes, the adopted shall be deemed to be a legitimate child of the adopters, and both shall acquire the reciprocal rights and obligations arising from the relationship of parent and child, including the right of the adopted to use the surname of the adopters. 2. The parental authority of the parents by nature over the adopted shall terminate and be vested in the adopters, except that if the adopter is the spouse of the parent by nature of the adopted. Parental authority over the adopted shall be exercised jointly by both spouses, and 3. The adopted shall remain an intestate heir of his parents and other blood relatives. Article 190. Legal or intestate succession to the estate of the adopted shall be governed by the following rules. 1. Legitimate and illegitimate children and descendants and the surviving spouse of the adopted shall inherit from the adopted, in accordance with the ordinary rules of legal or intestate succession. 2. When the parents, legitimate or illegitimate, or the legitimate descendants of the adopted concur with the adopter, they shall divide the entire estate, one half to be inherited by the parents or ascendants and the other half by the adopters. 3. When the surviving spouse or the illegitimate children of the adopted concur with the adopters, they shall divide the entire estate in equal shares. One half to be inherited by the spouse or the illegitimate children of the adopted and the other half by the adopters. 4. When the adopters concur with the illegitimate children and the surviving spouse of the adopted, they shall divide the entire estate in equal shares, 1/3 to be inherited by the illegitimate children, 1/3 by the surviving spouse, and 1/3 by the adopters. 5. When only the adopters survive, they shall inherit the entire estate, and 6. When only collateral blood relatives of the adopted survive, then the ordinary rules of legal or intestate succession shall apply. Article 191. If the adopted is a minor or otherwise incapacitated, the adoption may be judicially rescinded, upon petition of any person authorized by the court, or proper government instrumental acting on his behalf, on the same grounds prescribed for loss or suspension of parental authority. If the adopted is at least 18 years of age, he may petition for judicial rescission of the adoption, on the same grounds prescribed for disinheriting an ascendant. Article 192. The adopters may petition the court for the judicial rescission of the adoption, in any of the following cases. 1. If the adopted has committed any act constituting ground for disinheriting a descendant, or 2. When the adopted has abandoned the home of the adopters, during minority for at least 1 year, or, by some other acts, has definitely repudiated the adoption. Article 193. If the adopted minor has not reached the age of majority, at the time of the judicial rescission of the adoption, the court in the same proceeding shall reinstate the parental authority of the parents by nature, unless the latter are disqualified or incapacitated, in which case the court shall appoint a guardian over the person and property of the minor. If the adopted person is physically or mentally handicapped, the court shall appoint in the same proceeding a guardian over his person or property or both. Judicial rescission of the adoption shall extinguish all reciprocal rights and obligations between the adopters and the adopted, arising from the relationship of parent and child. The adopted shall likewise lose the right to use the surnames of the adopters, and shall resume his surname prior to the adoption. The court shall accordingly order the amendment of the records in the proper registries. Title 8. Support. Article 194. Support comprises everything indispensable for sustenance, dwelling, clothing, medical attendance, education and transportation, in keeping with the financial capacity of the family. The education of the person entitled to be supported referred to in the preceding paragraph shall include a schooling or training for some profession, trade or vocation, even beyond the age of majority. Transportation shall include expenses in going to and from school, or to and from place of work. Article 105. Subject to the provisions of the succeeding articles, the following are obliged to support each other, to the whole extent set forth in the preceding article. 1. The spouses. 2. Legitimate ascendants and descendants. 3. Parents and their legitimate children, and the legitimate and illegitimate children of the latter. 4. Parents and their illegitimate children, and the legitimate and illegitimate children of the latter. And 5. Legitimate brothers and sisters, whether of full or half-blood. Article 196. Brothers and sisters not legitimately related, whether of the full or half-blood, are likewise bound to support each other to the full extent set forth in Article 194, except only when the need for support of the brother or sister, being of age, is due to a cause imputable to the claimant's fault or negligence. Article 197. In case of legitimate descendants, whether legitimate or illegitimate, and brothers and sisters, whether legitimately or illegitimately related, only the separate property of the person obliged to give support shall be answerable, provided that in case the obligor has no separate property, the absolute community or the conjugal partnership, if financially capable, shall advance the support, which shall be deducted from the share of the spouse obliged upon the liquidation of the absolute community or of the conjugal partnership. Article 198. During the proceedings for legal separation or for annulment of marriage, and for declaration of nullity of marriage, the spouses and their children shall be supported from the properties of the absolute community or the conjugal partnership. After the final judgment granting the petition, the obligation of mutual support between the spouses ceases. However, in case of legal separation, the court may order that the guilty spouse shall give support to the innocent one, specifying the terms of such order. Article 199. Whenever two or more persons are obliged to give support, the liability shall devolve upon the following persons in the order herein provided. 1. The spouse. 2. The descendants in the nearest degree. 3. The ascendants in the nearest degree. And 4. The brothers and sisters. Article 200. When the obligation to give support falls upon two or more persons, the payment of the same shall be divided between them in proportion to the resources of each. However, in case of urgent need and by special circumstances, the judge may order only one of them to furnish the support provisionally, without prejudice to his right to claim from the other obligors the share due from them. When two or more recipients at the same time claim support from one and the same person legally obliged to give it, should the latter not have sufficient means to satisfy all claims, the order established in the preceding article shall be followed, unless the concurrent obligees should be the spouse and a child subject to parental authority, in which case the child shall be preferred. Article 201. The amount of support, in the cases referred to in Articles 195 and 196, shall be in proportion to the resources or means of the giver and to the necessities of the recipient. Article 202. Support in the cases referred to in the preceding article shall be reduced or increased proportionately, according to the reduction or increase of the necessities of the recipient, and the resources or means of the person obliged to furnish the same. Article 203. The obligation to give support shall be demandable from the time the person who has a right to receive the same needs it for maintenance, but it shall not be paid except from the date of judicial or extrajudicial demand. Support pendentility may be claimed in accordance with the rules of court. Payment shall be made within the first 5 days of each corresponding month, or when the recipient dies, his heirs shall not be obliged to return what he has received in advance. Article 204. The person obliged to give support shall have the option to fulfill the obligation either by paying the allowance fixed, or by receiving and maintaining in the family dwelling the person who has a right to receive support. The latter alternative cannot be availed of in case there is a moral or legal obstacle thereto. Article 205. The right to receive support under this title, as well as any money or property obtained as such support, shall not be levied upon on attachment or execution. Article 206. When, without the knowledge of the person obliged to give support, it is given by a stranger, the latter shall have a right to claim the same from the former, unless it appears that he gave it without intention of being reimbursed. Article 207. When the person obliged to support an oath, or unjustly refuses or fails to give support when urgently needed by the latter, any third person may furnish support to the needy individual, with right of reimbursement from the person obliged to give support. This article shall particularly apply when the father or mother of a child under the age of majority unjustly refuses to support or fails to give support to the child when urgently needed. Article 208. In case of contractual support or that given by will, the excess in amount beyond that required for legal support shall be subject to levy on attachment or execution. Furthermore, contractual support shall be subject to adjustment whenever modification is necessary, due to changes of circumstances manifestly beyond the contemplation of the parties. And that is the end. If this audiobook has helped you, please comment down below and like and share our video to someone who might need it. Thank you so much for making us your law school buddy.